There is an ongoing and public war of words between Prince Harry and Piers Morgan, and despite Prince Harry's recent settlement with Mirror Group newspapers, I personally think Piers Morgan has a very good point, which I'll explain why in this video. But first of all, if you're new to me, I'm Daniel Shen-Smith, a barrister of England and Wales, and I enjoy helping you to understand law, so please hit that like button and subscribe on the way in. I will be very grateful. So what am I talking about? Well, just recently, David Sherborne, counsel for Prince Harry, singled out Piers Morgan, to use the words of the news, in the following statement. They say that Piers Morgan, quote, knew perfectly well what was going on, referring of course to the hacking claims by Prince Harry against Mirror Group newspapers, because of course Piers Morgan was the Daily Mirror editor. However, Piers Morgan has responded in kind to say exactly what he thinks, and said as follows: I totally agree with Prince Harry that ruthless intrusion into the private lives of the royal family for financial gain is utterly reprehensible, and I hope he stops doing it. So why do I think he's got a point? Well, I think he's got a point because all of this use of private information vis-a-vis the stuff that Prince Harry has put into his memoirs and that was injected into the interview with him, Meghan Markle and Oprah Winfrey, there may well amount to a misuse of private information, which is quite frankly ironic given the nature of the claims by Prince Harry against the newspapers for hacking into his mobile phone. Now, don't misunderstand me. I'm not for one moment suggesting that any hacking, alleged or otherwise, is correct and that should have happened. However, equally, Piers Morgan has a point in that the memoirs by Prince Harry and the interviews, etc., disclose a great deal of what we might think of as private information, which the law caters for if it's been misused under the tort of the misuse of private information. So what do we mean by that, and how does a tort of misuse of private information come about? Well, there are two stages to a misuse of private information. Well, first of all, the claimant in such a case must first establish that they have a reasonable expectation of privacy in the information that's concerned, that's been disclosed. And this is the first stage of that test. And so many people over on X, particularly talking about being filmed in their car whilst breaking the law by way of example, often feel like they have a reasonable expectation of privacy in that information that is disclosed. In other words, the information about them being in a particular place at a certain time, their number plate, their face captured on camera, and so on. But that's not quite the case, because out in a public place, you don't generally have an automatic right to privacy, and you don't have a reasonable expectation of privacy if you're doing nothing out of the ordinary in a public place. But it might arise in certain situations, but most of those cases it will not. However, a lot of information, and I suggest, in my view, some of the information that was contained within Harry's memoirs and so on, ought really to amount to private information about those individuals written about or spoken about by Prince Harry and Meghan Markle. So that being the case, the first stage of that test would be met. Now, as I say, there is a distinct irony about all of this, because Prince Harry's legal claims are definitively in the sphere of the protection of private information. And so if various members of the royal family, about whom details were disclosed in this material, had and established a reasonable expectation of privacy in that information, then we move on to the second stage. This is a balancing exercise, which undertakes an analysis of all of the competing rights that are engaged. Firstly, the individuals about whom details have been disclosed, the rights of third parties, including the rights of publishers to impart this information, often balancing the rights of an individual against arguments of public interest and the right to a free press. However, this gets even more ironic the more we consider this situation, because the reasonable expectation of privacy was considered by the Supreme Court in various cases, one of which ultimately concluding that the objective test, what would an ordinary reasonable person think, and essentially approved the established objective approach, That being, would an ordinary reasonable person think that there was a reasonable expectation of privacy in those circumstances? Indeed, in Meghan Markle's case against Associated Newspapers, it was argued that Meghan's intention to publicise the letter that was subject to the proceedings meant that there could be no reasonable expectation of privacy, on the basis that the intention to keep information private is an essential element of the cause of action for misuse of private information. However, Justice Warby disagreed, stating that consent to the disclosure complained of, or the absence of such consent, is one of the factors. But these factors make no mention of an intention to publish, and there is no authority that an intention to publish all or some of that information at some future date is fatal to a claim. Still less that the absence of any such intention is a threshold issue on which the claimant bears the burden of proof. And just while I'm editing it, I thought I would simplify that even further. In other words, Associated Newspapers argued that because Meghan Markle had written this letter, either intending or risking that it would be leaked or published later, they argued that she didn't have a reasonable expectation of privacy in the contents of that letter. But the court disagreed, saying that she doesn't lose the reasonable expectation of privacy in the contents of the letter just because she either intended or risked it being leaked or published later on. So you can sense the inherent irony here. This information contained within the letter, the court said she had a reasonable expectation of privacy in. So hopefully that now makes more sense in the context of what I've just said. And then we come on to the consideration of confidence. Now, confidence is subtly different to private information and the misuse of private information. Confidence usually arises out of a contractual agreement or some other kind of moral agreement where the parties have agreed to keep something secret or private. However, previous relationships and private communications and storage of information and all of these kind of things can give rise to a degree of confidence. Depending on the nature and the equitable duties between the parties, confidence may arise. Now, albeit the royal family are obviously public figures and there are different considerations for public figures, but nonetheless, details of even public figures' private lives should ultimately remain private. Not only would there be a reasonable expectation of privacy for certain information, but there may also be a duty of confidence between the parties because they are privy to certain information that everybody else would not. And so this private relationship and the pre-existing nature between them can give rise to confidence and ultimately could give rise to a cause of action if it were found that there was indeed a reasonable expectation of privacy in the information that was disclosed. And if then going on to consider all of the other factors, this balancing exercise may mean that the information should not have been imparted to the public. So as I say, this public ongoing dispute between Prince Harry and Piers Morgan may well have a point. In my opinion, of course, but let me know what you think in the comments section below. And as always, if I could ask you for just one small favour and hit that subscribe button if you haven't already, that does help my channel grow and I appreciate it. So thank you for watching and I'll see you next time.